I'd like to welcome you all to the Lex Energy webinar on the GDPR and the impact on your domain names and enforcement. I will be handling the webinar by myself. Marina, who normally assists me from the US office, has, under GDPR rules, opted out of this one. So I am on my own. Just a little bit of housekeeping before I start. There is a chat box for you to insert questions. I'll try to answer them at the end. If I do see them come up during the presentation, I'll try to answer them. But otherwise, if you can just bear with me, I'll answer them at the end of the webinar. Alternatively, you can contact us at the information which you'll see on the last slide. So once again, welcome to this webinar. I see that it's quite popular. We had, I've seen quite a bit of interest in this. A lot of people have signed up for it. We're also going to provide a recording of this. It won't be on YouTube for all to view. You'll have to request a link from us. There'll be restricted access just on this particular one. So if you need that access, just let us know. I did change the heading of this particular webinar because I feel it goes slightly beyond the UDRP. So the purpose of today's webinar is not really to deal with the wording of the GDPR, which I assume most of us are familiar with by now, but rather assess the impact on law firms and trademark owners and how we can move forward with what we currently know. We've all been affected by the GDPR. I'm sure all of you have received thousands of emails asking you to click and accept and sign up for things you can't even remember you signed up for. So this GDPR has a substantial effect, especially in the domain name field. So hopefully I'll be able to answer most of your questions and address some of the issues that you may be facing. As a matter of housekeeping, the agenda for today is a brief introduction. I'm going to show you a few examples of practically what we faced with under this GDPR. Then relate that to domain name audits, watch reports, domain name recoveries and disputes, website takedowns, escrow transactions, and then a strategy moving forward. These are our recommendations based on the current position, and that will involve discussing domain name centralization, domain name policy, and strategy, the DPML, which is a domains protected marks list, and then we'll have some questions at the end, should you have any. So a little bit about Lex Energy for those of you that don't know who we are. We're a global domain name registrar and online brand protection specialist. We have offices in the UK, where I'm based, the US, recently Tanzania, Australia, South Africa, and Kenya. And we're directly accredited with the vast majority of registry operators. We offer over 1,000 extensions. That is why the GDPR is so relevant to us. Basically, we assist law firms and brand owners to manage their domain names and protect their brands online. So getting into the nitty-gritty of the GDPR, basically what it does do is it restricts how personal data about natural persons residing in the European Union can be collected, published, used, and transferred. It has a direct effect on what information is displayed on the Whois record for EU registrants, and it has implications, as I said, for trademark owners on how they can monitor and enforce their rights. What is important before I jump into examples is that each registry and registrar is interpreting the GDPR differently. The result is, as you will see, is inconsistent policies. There's no uniformity in the industry. I was at the ICANN meeting in Vancouver, and the amount of uncertainty that was coming out of ICANN was quite alarming and quite concerning. I thought we'd be further down the track for this, but I suppose it's like a meteor. You only panic when you kind of see it hurtling towards you, and I think that's what happened with the GDPR. Also, what's made us pay attention is the penalty, the 4% of annual global turnover, or 20 million euros. So because there's a penalty, we're all kind of panicking about this. I thought it was quite relevant when a couple of months ago the first email I got was from the Pakistani registry saying that they're redacting the Whois. And I thought, well, if it's reaching Pakistan, this is obviously quite serious. So this does not only impact EU registrars or registries, but anyone that deals with information coming out of the EU. So I'll show you some of the examples and some of the issues that we are facing currently at the moment. So if you can see, it may be a bit small. I'm not too sure how it displays on your screen, but on the left is the old Whois. This is something we've taken from our own domain name and the way we display the Whois going forward. Before explaining and going through the various forms of Whois, the Whois is basically the record and the information used to identify certain pieces of information relating to a domain name, and that mainly relates to contact information, the registrant, admin, technical, and sometimes billing contact. And it also provides information about the registrar, when the domain name was registered, when it expires, and sometimes when it was last updated. So there is a distinction between a thin Whois and a thick Whois. A thin Whois is a Whois that has limited data, and that is normally information about the registrar, dates, and some technical information. A .com domain name uses the thin Whois. That means that the actual registrar themselves publish the information and control what is being published. A thick Whois is the information, the complete set of information with all the context, and that is maintained by the registry. That is why, as a registrar, we have no control over the way the Whois is displayed on a thick Whois. That's, for instance, .info and all the new GTLDs, or the majority of them. While the thin Whois, we do have kind of control over that. And that is what's made a lot of ICANN accredited registrars nervous, is that they don't want to display too much information or display a person's personal contact information and be in breach of the GDPR. So as you can see on the left, once again, is the old Whois. It would have our company name, contact person address, telephone number, email address. When you look at the new Whois, you'll see that has all been redacted. It doesn't display. The issue there now is, say LexEnergy.com was an infringement, how would you, as a trademark owner or lawyer, know who registered that domain name? So that is the concern and the issue facing us today. And this could potentially lead to the increase of squatting. Move on to the next slide. I thought it would be prudent to show you the Whois of GoDaddy, since they're one of the largest commercial registrars. They've adopted the approach, being a US-based company, that if it's a non-EU client, they would still reveal information. Where they're based within the EU, they would redact that. So if you can see side by side, the GoDaddy.com domain name has GoDaddy as the owner, has the address, has their country code, telephone number, and email address. The parts highlighted in red there will be redacted if the individual is based within the European Union, and sometimes the company as well. So if it's an individual, there won't be any name, but if there's a company within the EU, it'll display the name and the country, but nothing else. So as you can see on the right-hand side, I just took that from a domain name blog, Domain Insight. There you can see it has been redacted. You only can see the registrant, organization, the country, and name servers. So that's how GoDaddy is displaying that currently. Just remember that these are temporary measures, because ICANN only implemented these temporary measures a couple of days ago. So most registrars are catching up, and hopefully we'll know what the final policy is, hopefully 6 to 12 months down the line. Enom as well, they're also a relatively large registrar. As you can see here, They have redacted information. What they've done there is they've simply replaced the information with data protected. So what you can only see in relation to their own domain name is the city, registrant city, province, postcode, and country code. Now, looking at the EU, what was quite ironic was a couple of days ago there was a meeting with the EU registry URID in London, and they directly fall under the control and ambit of the European Union, who came up with this lovely GDPR. And according to their interpretation, they feel that they can display the email address of EU citizens or residents, as well as companies, but will redact the contact information of individuals. What is interesting here is they've taken the most liberal approach to the interpretation of the GDPR compared to everyone outside of the EU, who has just taken the approach of let's remove as much as we can so we're not held liable. Their reasoning for keeping the emails visible was that they are important and relevant to the management of a domain name, to handle domain name disputes and any other issues surrounding the domain name. The address is not essential information, so that can be removed. One question that they do not answer is what happens if the email address identifies the individual's name, for instance, daniel.greenberg@gmail.com. Does that breach the GDPR? So there are a lot of questions out there. You can see on your screen a comparison between the Whois display of a company and an individual. We used our LexEnergy.eu. You can see it lists LexEnergy as the registrant, and it has our email address. I then took a random individual. I took Daniel.eu, and as you can see, most of the information has been removed, and the only thing that is displayed is really the email that's of any relevance. One other important thing that has been removed from the .eu Whois is the expiry date. So as you can see, you will know when the domain name was registered. So if you have to establish prior rights, you can look at that. The real issue now is you won't know when the domain name has expired. Now that is relevant, especially when it comes to a recovery. You want to know, do you send off a cease and desist if the domain name is expiring in a month or 2 months? Do you put it on a backorder service, which is a snap service where the service tries to register a domain name the minute it becomes available? Or do you go ahead and file a complaint under the EU ADR? So these dates are very important. I have been informed that this can be requested from the registry, and there's certain processes. Having said that, each registry operator will have its own process for retrieving relevant information, and I'll get into that in a little bit more detail in later slides. The UK, one of the most popular CCTLDs, as you can see there, they've basically redacted all contact information. You have the registered date, expiry date, but the only thing that they kind of confirm is that they were able to match the registrant's name and address against a third-party source. But otherwise, you won't really know who's behind it. It does register, it does have the registrar tag on that, but that just tells you who manages the domain name. So that is what the UK displays. Belgium has a similar approach to .eu with companies and individuals. As you can see on the left, companies Whois would display the information. It hasn't really changed much. But with an individual, it has. So all that information has been redacted for the fundamerva.be. That's the example that I used. There is a way of contacting the registry to retrieve that information. One thing that is important to bear in mind for those that work in law firms or enforce their IP online is that some registry operators, when you do request the information and they do supply it to you, they may notify the registrant of the domain name that you did request the information, and they could potentially reveal the grounds on which you based your request. So bear that in mind when taking action or potential action, because you don't want to start the process, make them aware of it, and then not go further with that particular action. EU said that they won't notify the registrant that someone has requested information. They said this is due to law enforcement. They don't want this to impede any investigations that may occur around a domain name. While preparing for this webinar, I came across the .za namespace. A lot of our clients are based in South Africa, and this obviously impacts them now. You know, I was quite astounded to see that the GDPR has reached the tip of Africa. So as you can see on the left-hand side, that was what the Whois looked like before for lexenergy.co.za. So it was a standard Whois. You could get all the information that you're normally accustomed to. On the right-hand side is what the registry operator has now done. They've redacted their information. They only display what is in red there, and that is Lex Energy Limited, the company name, that we're based in London, and that the country is GB, Great Britain. If we were an individual, it would not display that name. So if you want to enforce your rights within the co.za namespace, this will be slightly more difficult now, in that you would have to request this information. That's not available. So I've probably made most people uncomfortable knowing that a lot of information is not available, but there are certain steps that can be taken to try and address the issue based on information of what we have currently at the moment. So dealing with domain name audits and domain name watch reports, to give you a bit of background of these services, a domain name audit is really the health check of a domain name. What we normally do is we would enter a particular trademark. We would then identify domain names that incorporate that trademark or that are identical or confusingly similar. We then extract the Whois information, or used to, and then present that to a client or to a law firm so that they could assess where a client's domain names were, who managed them, who owns them, who controls them. Watch reports, these are monthly reports where we identify domain names that infringe upon a trademark, and then this is reported to the law firm or the trademark owner. What was relevant prior to the GDPR was the Whois information. That allowed a client or a lawyer to look at the information and then determine whether they would take action or not. So the current situation is that the domain names will be found, so that's not a problem. However, the results, as you can see from the previous Whois information, will be limited or unavailable, and dates on certain extensions will be absent. So what we're currently doing, and we're working with our clients on this, is we're utilizing historical Whois data that we've captured and third-party sources have captured over a period of time. This information will be relevant, probably and valid for the next couple of months, so we can try weather the storm until probably say the end of the year, until that information becomes outdated. It obviously won't address the issue of new registrations where that information is not available. What we will see a lot of is that squatters are likely to use an individual's name or a name with a European address so that they can kind of fall under the GDPR and, in a way, use a free privacy service, in that they know now that it will slow down the process in identifying who they are. Then the next thing is, as I said, retrieving the Whois information will be slow, as each registry operator will have their own procedure for requesting that type of information. The previous results will be limited, but when it comes to recovery actions and disputes, that's where things get a little bit more complicated. It could happen that you won't know who has registered a domain name, so you want to send your cease and desist to a particular party. We have been told that registrars will start implementing a contact form or have an anonymized email address that if you email that anonymized email address, that registrant should receive the cease and desist. The problem is you won't know if that domain name was registered by an employee, a vendor, a business unit. What happens is some employees, vendors go rogue and they do their own thing with domain names, and there you are dealing with a potential dispute not knowing who the party is. So it will be more difficult and costly. Like I said, we can rely on archived Whois for domain names that pre-existed or were registered prior to the implementation of the GDPR. There are rumors that you will have to get a court order to recover this information for new domain names. This will make the process extremely expensive because you would have to obtain a court order in the jurisdiction of where the registrar is based. So if the registrar is based in India, China, you would have to get the court order in that jurisdiction. The issue there is you can get a court order, say, for the registrar to release the information of lexenergy.com. I could then transfer the domain name, which takes about 5 days, depending on the domain name extension, to another registrar. There, the lawyer has gone and requested a court order for a particular against a particular registrar, and now the domain name has been transferred. So it could result in the domain name registrant hopping from registrar to registrar. A practical recommendation is if someone has to go down the route of a court order would be to get the registrar to lock the domain. What that means is that they will prevent the domain name from being transferred to another registrar. So at least you lock them down to a specific one. And then in the court order, it may be worthwhile, if appropriate in that jurisdiction, to request the Whois information of all domain names that incorporate a certain mark. Because what normally happens is a squatter, if they use a registrar, they may have multiple registrations or multiple infringements targeting the same particular mark. So that may be one cost-effective solution. .sucks, there were some conversations saying that .sucks, which has caused a lot of issues within the domain name space, they said that they would require a court order issued in the Cayman Islands. This is obviously hearsay, so we don't know if it will stay like that, but that would make it very difficult because .sucks could fall within the realm of freedom of speech. So you're dealing with a freedom of speech element and then obtaining a court order in the Cayman Islands. I'm not familiar with that jurisdiction, but I can't imagine that it is easy to get a court order in that country. So this will impact the UDRP and URS in that if you can't get the information and you need to file a UDRP, you won't know who you are dealing with. And I will deal with that in the next slide. If you don't know what information or the information that lies behind a particular domain name. Because there's so much uncertainty, we would say that each client needs to pick its battles. Everyone's kind of laying low at the moment, not knowing what to do. We say that you should adopt a three-stage approach: assess, monitor, enforce. And assess means that once you find domain names that are infringing, look at them, look at the website, see if there's any contact information there. How serious is it? If there's no website and you can confirm that they're not using it for any email scam or anything like that, that would form probably a lower priority. If there's a website that's up, that's something that can be taken down and it's not affected by the GDPR, but the domain name itself is obviously higher, it ranks higher, and then you can decide, proceed with a cease and desist or a UDRP URS complaint. If you feel or the client feels that there's not enough information to determine the level of risk, rather monitor it. Monitor it for a website, so when a website does appear, you can then assess to see if it does infringe the client's trademarks. Maybe place it on back order. As I mentioned, a back order service is a service that monitors a domain name, and the minute it's deleted, it tries to re-register it. So that is a solution. And then the last resort is enforcement. Now, with enforcement, I think there'll be two approaches to that. We'll either see a lot of registrants saying, well, they don't want to file the UDRP because they don't know who they're filing against, or people may resort to filing more UDRP complaints because they won't know who the party is behind a particular registration. But like I said, I'll get into that in the next slide. Each CCTLD will have its own processes for revealing who is details. And as I said, some may introduce a form, but that will only be a conduit system. So they would merely pass on your information. They will not disclose that information. So although you're sending a cease and desist, you hope that if it is an employee or a vendor, that they would respond and you would know who you are dealing with. Another important issue is escrow, which I will deal with at a later date, but I thought I'd mention that now, as when you buy a domain name, you won't know who the party is. It'll be difficult to determine if the information has been updated to the new registrant. So that kind of throws a spanner in the works when there's an anonymous approach to buy a domain name and you use an escrow service. That leads us on to the anonymous approach, which will be slower and more difficult to locate the registrant. We may have information where we could contact them via the forms I was talking about, but you really won't know who you're dealing with. So I think the anonymous approach holds true on both sides, that the party making the anonymous approach and the party receiving it don't know the information of each other. So there's this anonymity in the process, which can make it very difficult when it comes down to negotiations. So dealing with the UDRP, there are a few providers out there through which you can recover your domain name. Most of you know the National Arbitration Forum based in the US. Then there's WIPO. A lot of people file through WIPO. There's the ADR.EU, the Czech Arbitration Court. They're a relatively new UDRP provider. Then the ADN DRC, they're the Asian Domain Name Dispute Resolution provider, and then the Arab Center for Dispute Resolution. I haven't used them before. I don't know much about it. But each of these providers have their own rules relating to UDRP complaints. And what I would advise lawyers to do that file complaints is to shop around and see which ones favor or have favorable supplemental rules. What I mean by that is, for instance, the National Arbitration Forum. When you file a complaint, the filing fee is slightly less than WIPO. It's about $200 cheaper, but your fee is non-refundable. So the minute you file the complaint, if you do withdraw straight away, you would lose your filing fee. I know with WIPO, if you withdraw before service or before a panelist is appointed, they can refund a partial amount of the fee. I know with the Czech Arbitration Court, they do have a reduced fee if it's a default decision, which is the majority of UDRP complaints. So they, I think it's about 700 euros. And then there's also a refund policy if you withdraw the complaint. Now, the way that a UDRP works is that you may, and it happened before the GDPR, someone may be hiding behind a privacy service. So a complaint was filed. When a complaint is filed with a provider, they have to confirm the information with the registrar. When the registrar confirms that information, the complainant is then requested to update the complaint to reflect the new owner, because what they do is they remove the privacy service. So then you know who the complainant is. So it may be a interim solution is that when a complaint is filed and the information is released, if it's then identified that an employee registered the domain name, someone within the company, then at least you can withdraw the complaint and reduce the costs. So in a way, that partial refund does save money. It may be a cheaper option than obtaining a court order. Court order, obviously paying an hourly rate in a foreign jurisdiction can be expensive. So I would highly recommend looking at the various UDRP providers that are out there. Dealing with website takedowns, the process or the GDPR will slightly impact takedowns. It won't impact takedowns that are based on fraud, phishing, and copyright infringement, because if the infringement appears on a website, you're taking it down based on the relevant rules of the jurisdiction where it's hosted or where the copyright holder is based. In some cases, a takedown involves the suspension of a domain name, and that can be done in a variety of ways. One is, reporting inaccurate Whois, but if you don't know what the Who is, how do you report that it's inaccurate? Also, what will be very difficult is if someone does use a generic name, a domain name, say for instance, it's domains.com, for us to request the information based on trademark rights, won't hold water with the registrar, because we don't have a trademark for domain names that's descriptive. It's required in the industry, so they may not release that information. They could potentially release it if it is a threat, and they feel that the risk is extremely high if they don't, or someone could be prejudiced by that. But that will take time, so that could delay domain name suspensions. Also, less obvious infringements. Sometimes you require an investigation in who the domain name owner is to find out if they have any other domain names, if there's a pattern of conduct, kind of connecting the dots to see whether it's part of a larger type of infringement. That will be quite difficult now, because you won't have these key pieces of information that we used to have. So that could be a problem. But based on historical Whois data, you could try and link up certain pieces of information. There are other ways that we're looking into to try and link up common pieces of information that would kind of link a few domain names together so that they could be bundled in a takedown. But like I said, it is not going to be an easy exercise. Escrow transactions, this is very important, as lawyers deal with a lot of domain name purchases, domain name transfers that require the payment of a purchase price. What usually happens, the process works as follows. You agree on a price. You then enter into escrow. So what happens is the purchase of the domain name deposits the money with the escrow agent. The seller then supplies the auth code or transfers the domain name. Once the domain name is in the control and uses the buyer's information, the escrow agent would then release the funds to the seller. The issue now is that information won't be available if the parties are individuals, and in some cases companies, if that information is redacted. So you won't know if the domain name has in fact transferred. You will know if it's moved from one registrar to another, because that will be displayed, but you won't know if the information is updated. So for instance, a fraudster could transfer it to another registrar but still keep it in their name. So it would be important to try and get some sort of confirmation from the seller that they own the domain name. And this could be in a variety of ways, one of which would be asking them to update the name servers. So if you see that they've updated the name servers on the domain, you would then know that they have control over that domain name at the very least. Use a credible escrow agent. So there are a lot of escrow services out there. You need to use a company that understands domain names, because if they don't, this could lead to issues. Also use a registrar that can confirm the transfer and update of the Whois information. So that is where companies like ourselves come in, where as a corporate registrar, we would supply that to our client and confirm on our end, because we could confirm that it's in our control and what the information is, because that would be accessible to us. So that's important, making sure you're dealing with a reliable escrow agent and a reliable registrar. Now, I've probably given you all a bit of a headache with all the issues out there, and it can be a bit overwhelming. But I think there are some steps that can be taken to mitigate the risk. So in this particular instance, one that we've identified is domain name centralization. For years, we have been advocating that trademark owners and law firms need to centralize their domain names. Lawyers, from a law firm's perspective, we say that if a lawyer is managing your trademarks, they should also manage your domain names, because the trademark and domain name portfolios need to kind of mirror each other. And the same way is that you would not allow a marketing company to manage your trademarks, you should not allow your hosting company to manage your domain names. And the reason for the centralization is that it's important to know what you have. So from a law firm perspective, if you're managing all your clients' domains, you know what they have. If a domain name is identified that is outside of that centralized portfolio, that could be deemed to be an infringement. It then also saves time in having to identify whether someone else has registered a domain name within the company or a vendor. So at least it gives the client certainty that their domain names are in one place. What often happens is a brand owner may use, say, one registrar in the US, another one in Australia, another one in Europe, and their passwords are not kept centrally. It's managed by different business units in different offices around the world. And when it comes down to identifying it, they won't know who these domain names belong to. They won't even have a contact address. So that is why the time is now to start the centralization. And like I said, knowing what you have is crucial. It also makes sure that your client can go to a single resource to get the domain names that they have. Also, in selecting a registrar, you have to make sure that they are also GDPR compliant, as you don't want them releasing information to the general public. And in this particular case, it may have an impact on trademark rights. So, for instance, in the past, where we had all this information available to us, we could identify where the parties were, develop a strategy, come up with an argument. Now there may be a case for extending trademark protection to the countries that have high domain name disputes. So that, for instance, would be China and Russia, where it's extremely difficult to identify who a party is, and because of the rules, they tend not to respond to cease and desist and that type of action. So this could be an opportunity for lawyers to assess a client's portfolio to make sure that it at least gives them the tools to enforce their rights in those difficult jurisdictions. One point I'd just like to add there is, in some cases, if a domain name is generic, it may be difficult to determine who owns it. So if your client owns the domain name business.com, for example, if that whose information is not available, they won't know who to contact. It will be difficult to try and get that from the registrar, because they won't disclose that information if they know that it's just a generic domain and there's no real infringement there. The domain name centralization process as a partial solution, I would call it, kind of falls in line with the domain name policy and strategy. Now, what that is a set of documents that sets out how domain names are managed, and that includes how they are registered, renewed, transferred, the naming conventions. So going through this particular slide, it lists key pieces of information that a trademark owner should be aware of and have in place in light of the GDPR. So what we say is you need to determine what domain name should be registered. So the client should have a policy of saying what extensions are important to them. What are the high-risk ones? Which countries do they trade in, because they need to secure those. Country code top-level domains, or where they intend to trade. Look at generic terms relating to their industry. Naming conventions, for instance, Google Search, Google Pics. So what is a naming convention when it comes down to registering domain names? Identifying key trademarks so you can register corresponding domain names. What we don't advocate is going ballistic and registering everything under the sun, which some people do, but rather having a strategic approach. If it's identical, fine, register that. If you see that there is a pattern of registering typos, maybe look at that. But due to the number of extensions out there, that's not practical. So come up with a concise strategy for key trademarks, ones that do need to be protected. Then you need to determine who will they register the domain names with. That should be a single provider, just so that falls in line with the consolidation aspect that I previously mentioned. You need to determine who is authorized internally to approve domain name requests. We often find, and I'm sure legal's familiar with this, where a domain name, they'll find out that marketing has registered a domain name with a third-party provider, and now it's in that third-party provider's name. Legal has to take steps now to try and transfer that in, contact the person, or it could happen that a product has launched and marketing has made an announcement, but the domain names haven't been secured. So it's important to determine and centralize the communication channel for domain name requests. Also, the information used to register a domain name should be standardized. So that means a single telephone number, a single email address, and company name, which should match the trademark owner. The reason for this is if you know that you're using the same email address, if you ever need to recover a password or obtain information, if you have access to that email address, it does make it a lot easier. Place restrictions on who can register domain names, and this should normally apply to about 2 or 3 people within an organization that are responsible to register domain names. And then in light of the GDPR, there should be consequences for not adhering to a domain name policy and strategy document. The reason being is if an employee goes and says, okay, well, I'm going to register lexenergydomains.com, and then I have to incur the cost of obtaining the Whois information, potentially getting a court order, and then I realize it's them, they need to be aware that if they go out of that, if they breach this policy, that there are consequences for that. I know it doesn't sound very nice, but under the GDPR, I think it is relevant. Then in that strategy document, there needs to be an enforcement strategy. In light of the limited information, look and set the criteria for what you monitor and that what domain names you need to keep your eyes on. Those are ones that you want to determine if it's an infringement at a later date, which ones are high risk, which ones you want to recover. So once that has been predefined, it would make it a bit easier, and it may whittle it down to a fewer domains than when you get these traditional domain name watch service reports where you see hundreds of domain names and you don't know where to start and you can't go after them all. So rather pick the battles. I'll talk about a blocking option in the next slide. But what is important with this type of policy and strategy is to communicate it to all employees, vendors, third parties. So if you have or if your clients have a policy of how they bring on vendors, the domain name policy, it can be kind of a summarized version of the rules on what they can and cannot do. This needs to be communicated to third parties. So kind of the restrictions placed on them. For instance, you wouldn't allow them to file a trademark for a client, so the same, they shouldn't register a domain name. And I always tell people, just because a domain name is easy to register doesn't mean that everyone should do it. One of the potential ways of mitigating the risk under the GDPR is the Domains Protected Marks list. And this is a blocking service which many of you may be familiar with. And what that does is, if your client has a trademark that has been validated by the Trademark Clearinghouse, they can block that term across 250 new generic top-level domains like .business, .ventures. So that block, you pay a lump sum fee for 5 years and no one can register that. But it can be overridden by another trademark owner, so that's possible. But at least a cyber squatter would not register that. That is cost-effective in that you don't need to register or you don't have to maintain a large portfolio of domain names. It is a block and would deter people from registering that domain name. So we would suggest that for core trademarks or for trademarks that have been subject to high levels of abuse and infringements in the domain name space. So that is a kind of a summary of the strategy. What we will be doing is we will be updating the information as it comes in, as ICANN changes their rules. We are working with a lot of clients to provide the Whois information where we can. We have a lot of archived Whois records that we can provide to our clients that are seeking to find out who the party is. We do have investigation tools, and those are kind of some of the resources we have to look at now, bearing in mind that it may be difficult to deal with the registry operators. Also, as a registrar, we do have access to certain information at the registry level, and because we have a relationship, hopefully we can facilitate that with law firms and brand owners to get the information without having to go through the court process, because that is not that's not a process you'd want to go through, especially in the domain name space where things can change quite quickly. So with that, it brings us to the end of this particular webinar. I hope you've found it useful. If there are any questions, if you can add them into the chat box. I'm sure there may be some questions on what was discussed. If not, you can send us an email to support@Lex Energy. My email is Daniel@Lex Energy, so you can just replace that, and our contact numbers are there. If you have any issues with domain names that have cropped up recently, get in touch and we'll see whether we can assist you. So managing this by myself, I don't see any questions at the moment. So yeah, feel free to reach out to us if you do have any questions, and hopefully we can assist you in that regard. So once again, I'd like to thank you for attending this webinar, and hope that you'll sign up for future webinars. Thank you for your time.